Greetings, I'm David McSherry and this is Sam Murkoff.
And we are the side that's going to be debating that it is not ethical for hospitals to drug test their employees in states where marijuana is legal, such as Colorado.
I'm Steve Gothier, this is Mark Swarzak. We're debating that it should be ethically legal for hospitals to drug test if marijuana is on the docket.
Okay, so we'll begin. Urinalysis detects the presence of inert, fat-soluble byproducts of marijuana, the most common of which can remain present in the urine for months after past marijuana use, long after any psychoactive effects have already worn off. McDonald et al. Recommended against using urinalysis as a diagnostic tool to identify employees who represent a job safety risk from cannabis use. In 2004, researchers Levine and Rennie found that pre-employment drug testing has a very low yield and is not a replacement for a comprehensive campaign against impaired hospital employees. They found that in the first 8 years that a particular hospital had pre-placement urinalysis required, there was only one confirmed positive test for marijuana out of 2,329 individuals tested, giving a response rate of 0.04%. The total cost to find this one case in those 8 years was $93,160. In 2012, a researcher named Hickox published an article in Hofstra Labor and Employment Law Journal that validated the fact that employers are not allowed to accommodate for the use of marijuana on the job site based on marijuana statutes and bills. However, drug tests do not account and do not test for impairment at work or in the job site. Hickox writes, and I quote, "Most employers are concerned about the effects of the use of marijuana and other illegal drugs on employees' performance, but a positive drug test can result in adverse consequences for the employee even if that employee is not under the influence or intoxicated by marijuana while at work. This could lead to much more harm than good." This paper by Hickox proposes a solution to this dilemma. And this is something that our side agrees with. Quote, "Employers should rely on evidence of actual impairment of the applicant or employee rather than a drug screen. With individualized assessment of impairment, employers can still promote safety and productivity in the workplace while giving marijuana users in states where that's legal, an opportunity to continue working productively," end quote. So to sum this all up, while employers should be concerned if they notice an employee inebriated while at work, we're not saying that's okay, the current practices of using urinalysis drug screens for employees for pre-employment or random drug screens is not an accurate tool to determine the safety of a particular individual as they are at work.
Alright, thank you, Sam, for that. And while we note the fact that a more accurate tool is needed to determine acute marijuana intoxication, our rebuttal is that marijuana affects every user differently, and those effects can depend on various things: the person themselves, their mood, personality, size, and weight, the amount taken, and whether it is mixed with anything else, and the environment in which the drug is being used. If marijuana is used in said workplace, it can affect the health and safety of the person taking it, as well as those around them, as well as have adverse effects on their productivity. Marijuana is known to have the following effects, said Wadsworth et al. 2006, short-term memory problems, impaired thinking, loss of balance and coordination, decreased concentration, changes in sensory perception, impaired ability to perform complex tasks, decreased alertness, and decreased reaction times. All of these are integral to a nurse's job and profession for any type of healthcare worker. The effects of marijuana can last from 2 to 6 hours on top of this as well. These side effects may make it hazardous to use marijuana at work, particularly if a person is operating heavy machinery or driving a vehicle. There's also a greater risk of an accident occurring due to the performance of even simple manual tasks. Regular marijuana users may start to exhibit signs of loss of energy and interest in their task, causing their performance to suffer. They may also find it difficult to learn new work skills. And again, something that's very important to nurses, physicians, and everyone in that healthcare system. In summary, we feel policies and procedures regarding drug testing should be firmly in place at healthcare organizations in order to prevent their employees' performance to decline due to habitual marijuana use. This potential decline in performance could expose the organization to a lawsuit if a patient is injured due to employees' carelessness, regardless if they were acutely intoxicated or simply had marijuana in their system.
Thank you, Steve. And we're going to talk about our case, or I'll be talking about our initial case. And for this, I'm actually going to focus on the law portion of things because, as we know, both ethics and law are very, tightly knit together. Several laws are actually driven from ethical principles. So, with that said, I'm actually going to open up with a quote directly from our Posgar book at the beginning of chapter 6, which is the introduction to law. Laws are enacted to regulate human behavior for the benefit of society. They are designed to prevent harm to others while protecting the rights of individuals. In the law, we are taught that we have a duty to care, and that if we breach that duty and someone is injured as a result of that breach, there will be a penalty to pay, which could be financial loss of license, and or jail time to be served. So with that being said, again, our approach is the more legal route. Marijuana actually remains illegal under federal law. Any workplace that receives federal funding or subject to federal regulations require the testing of safety-sensitive workers such as nurses. And they must continue to consider marijuana a prohibited substance. And this is actually according to the Drug-Free Workplace Act of 1988. Keep in mind several hospitals, both public, or I should say profit and non-profit, receive federal funding, whether that's through Medicare or through other funding. So though the legalization of recreational use of marijuana may make enforcing workplace policies for after-hours use increasingly contentious, Washington State and other states such as Colorado that have legalized marijuana use have ruled in favor of employers in the past when employees have been fired for illegal use of marijuana. In 2011, the Washington State Supreme Court ruled that an employer can fire a worker who uses physician-authorized marijuana even when the worker uses it only at home and exhibits no impairments or no impairment at work. Because the state's marijuana law did not spell out any provisions regarding workplace use, the Supreme Court found it allowed no recourse in employment disputes. And this is actually the case of Jane Roe versus Teletech Customer Care Management, LLC. Similar rulings have been made in other states with legalized marijuana, like Oregon and California, according to Martin 2011. In summary, marijuana is an illegal drug under federal law, which may carry a fine or criminal conviction. Work performance may be affected, the safety of the user and others, such as patients, may be affected, and perhaps most importantly, marijuana use remains excluded from the ADA's protection. The ADA adopts the Criminal Code's list of controlled substances to define such drugs, and marijuana remains listed there as a federally controlled substance. Thus, a marijuana user isn't considered to be, quote, qualified individual with a disability, end quote, merely because of that use. Nurses are a profession and should be held to a higher standard. Therefore, partaking in federally illegal activities should not be allowed or accepted.
Thanks, Mark. In response to the idea that marijuana is federally illegal, there are a few points to be made. First, a law is just a legal representation of what is ethically right and wrong among the people that it governs. The people of Colorado and other states have decided that marijuana has a legitimate medical use, which has been verified by scores of medical professionals. Furthermore, in Colorado, the people have voted to legalize its recreational use and view it the same as alcohol. Secondly, the President of the United States has admitted to using marijuana and has stated that it is no more harmful than alcohol. He has also stated that federal agencies will not interfere with state laws on the matter. More importantly, the State Board of Nursing, by definition, is a state-run entity. It serves the people of the state in which it exists. Therefore, State Board of Nursing should enforce state laws. If there was a federal Board of Nursing, then the entity would enforce federal laws. Responding to the statement, an employer is allowed to decide what either employee does outside of work. I will summarize an article by Dr. Michael in the Journal of Business Ethics from 1998. He first postulates that an employee's right to privacy is violated when an employer collects or uses personal information which is irrelevant to the terms of employment. He then argues that drug testing is relevant in service positions such as nursing and is therefore ethically justified within the terms of the employment contract. However, in conclusion to his argument, and examining both sides of the issue, Michael arrives at, and I quote, "While drug testing can be ethically justified under the terms of an employment contract, it still amounts to treating employees as a means to an economic end, and is therefore fundamentally inconsistent with substantive valuation of human worth and dignity," end quote. If autonomy is an ethical principle that we value in healthcare, then we should not deny healthcare workers the ability to decide the legal substances that they ingest, as long as it does not affect their ability to perform the duties in their employment contract.
I think you have rebuttals.
Yes. Additionally, I wanted to add that in Steve's response to our initial case, you had stated that there are negative effects of marijuana consumption. You stated short-term memory loss, inability to concentrate, impaired thinking, changes in sensory perception, loss of balance and coordination, decreased alertness. All of these are really bad things, and our side is not arguing that these are not side effects of marijuana, or that these should, that these side effects would have no mal effects on the job that a nurse performs. Just like a nurse would not be allowed to drink alcohol a certain amount of time before they go to work, we don't think that it would be right for a nurse to smoke weed before he or she goes to work, because alcohol can cause many of these same side effects. So there's no resistance from our side about that fact. In fact, we agree that there needs to be some sort of rapid test, on the spot, objective test to determine the level of inebriation of somebody. However, until that point, I'll go back to the article by Hickox from the Hofstra Labor and Employment Law Journal in 2012, who wrote that until these types of rapid tests can be developed, quote, employers should rely on evidence of actual impairment of the applicant or employee rather than a drug screen. With individualized assessment of impairment, employers can promote safety and productivity in the workplace while giving medical marijuana users an opportunity to continue working productively, end quote. There's no need in our side's view to punish a professional who's remaining within the legal boundaries of his or her state if it's not negatively affecting his or her duties that are spelled out in their employment contract.
Okay, so so I definitely think we're certainly in agreement with having some type of rapid drug screen to show for acute marijuana intoxication. Clearly, the testing involved today is obviously outdated, and so I think we can agree on that. And once a more rapid test or one that shows acute marijuana intoxication, just like a breathalyzer test with alcohol, once that's available, I think that the federal government may be more willing to legalize marijuana, as studies have shown that it's just as safe, maybe even safer than alcohol. But until then, since it is illegal at the federal level, and since nurses should and currently are held to a higher standard than the norm, because we are a profession, having them partake in a federally illegal activity, in my opinion, in my view, is kind of a double standard. If you're held so high, but then you can allow them to partake in this, regardless of the state level. And furthermore, I have here, I was thinking about it, healthcare organizations need to be more risk averse because they are healthcare organizations. They take care of patients, and they're always at constant risk, especially nowadays. They're always at risk for lawsuits. So I kind of wrote down an example here. Let's say Nurse Johnny was completely sober, was not under the influence at work. They smoked marijuana 5 days ago on their time off. They actually had 5 days off. They were on vacation. They were in Jamaica, wherever they went, where it's actually legal. Who knows? Or they're back in Colorado. They're just enjoying hanging out. Smoked 5 days ago, and again, not under the influence at work. They accidentally harm the patient. God forbid. The patient's hurt or even dies. The organization, either its protocol or what have you, the family suggests it or recommends it because Johnny's just a kind of a unique eccentric character to begin with. So they, have him take a blood test, and he's positive for THC, that's found in marijuana. So now this exposes the hospital, the Nurse Johnny, really everyone involved is exposed to this lawsuit or will be sued. So really, I guess in the grand scheme of things, like what I'm trying to get at is that I just don't know if right now the risk of allowing nurses to smoke, or really not even having a testing policy, kind of doing away with testing policy because it is outdated. I don't know if that doing away with it is necessarily worth the, I guess, reward of allowing nurses to partake. I think it has too much risk involved today. But I think certainly with as technology advances and better testing gets out there, and I think that that's inevitable with the I guess legalization of marijuana. There's going to be more tests done. There's going to be more rapid tests to show acute intoxication. I think it's just a matter of time. But until that time comes, again, I think that we just need to stick with it being, I guess, frowned upon. So. All right, is that it? Thank you.
Thank you.
Thank you.